Good morning, everyone. It's Dana Zimmerman from Fidelity. We'll just wait a couple of minutes just to give people a last chance to log in, so we should be starting shortly. Thanks. Good morning, everyone. We're going to get started. Thank you for joining us this morning. I'm Dana Zimmerman with Fidelity National Title Group. In addition to being the claims liaison for the Fidelity New York Agency Department, I'm also the CLE and CE coordinator in New York State. And we're proud to offer our next combined CLE and CE program this morning. Before we get started with Dennis Chorney's presentation on the TIRSA Owner Extended Protection Policy, or TOEPP, the DFS requires that we read the following statements before the presentation. First, display of approval documents. Provider, course, and instructor approval documents issued by the New York State Department of Financial Services are available for viewing by each attendee. These documents serve as documentation that your course is currently approved for credit. They also verify the approved number of credits, the license classes eligible to receive credit, and the course approval number you will need to renew your license. Second, attentiveness during class. During the instructional period, you may not conduct insurance or other business or read materials unrelated to the course. All electronic devices must be silenced. Texting is not permitted. Third, attendance policy. The New York State DFS requires attendance for 100% of the approved class hours. If you log in late, you may be denied credits for the course. If attendance requirements are not followed, instructors and providers may face disciplinary action, in which case credits may be jeopardized. Fourth, course completion documents. When you have successfully completed a course, you will be issued a course completion document showing the course approval number, eligible license class, and the number of credits you have received for completing the class. Retain this certificate to use when renewing your license and in the event of a department audit as proof you took the course. Remember, you cannot use credits for any course more than one time per eligible licensed class. Now, on the first page of the course materials that were made available to you in the email sent last Friday, you will find an attendance verification form. Please print out that form, fill it out, and email or fax it back to me after the program. My contact information is listed on the form. Please indicate on the form whether you are looking for CLE or CE credit, and if you would like CE credit, please include your DFS license number or numbers if you have multiple entities. At various times throughout the program, you will see 3 different program codes pop up on the screen, and Dennis will also announce them. You must include all 3 program codes on the attendance form to receive credit for the course. Also, if anyone has any questions during the presentation, there is a Q&A tab on the bottom right of the webinar. You can type your questions there, and Dennis will respond to you after the webinar. Lastly, on the last page of the course materials is an evaluation form. Your feedback about the presentation is important to us, so we ask that you please fill it out and return it to me with the attendance verification form. Now I'd like to introduce my colleague, Dennis Chorney, who will be presenting on the TIRSA Owners Extended Protection Policy, or TOEPP. Dennis has over 23 years of underwriting experience in the title insurance industry, having worked as underwriting counsel at Lawyers Title, Chicago Title, and now the Fidelity National Title Group. In 2015, Dennis was appointed New York State Counsel for the FNF family of title insurers. Dennis, I turn the presentation over to you.
Thank you, Dana. Thank you for that introduction. It actually kind of made me feel a little old. But anyway, I will spend the next 15 minutes or so speaking to you about the TOEPP policy. Now, what is a TOEPP? Well, TOEPP is an acronym for the TIRSA Owners Extended Protection Policy, and that's a handful and a mouthful, so I will basically stick with the acronym of TOEPP. It was originally filed in 2001 and approved by the New York State Department of Insurance on January 11th, 2001, and it was never amended since 2001. So it's basically its original form since its inception. And what it is basically is an owner's title insurance policy that offers enhanced coverages that are in addition to the coverages provided by the standard ALTA 2006 policy. Now, just to revert back to a little bit of background on the TOEPP and its origin, it's actually an offspring of another enhanced product that we're all familiar with, the market value rider. The market value rider was adopted because of a 1980s claim on Long Island, actually predates me. And in that claim, the insureds purchased property in a subdivision that quickly rose in market value. Soon after, basically a claim hit the subdivision. The claim challenged the deed chain, and it exposed the insureds to a potential full failure of title. That 1980s claim revealed a shortcoming in the then existing owner's policy. Due to significant increase in the property values, even a full payment under the policy would not really indemnify the insurers for their total loss because the properties went up significantly in value. So as a result, the market value rider was created and adopted by TIRSA in 1993. After that form was adopted, soon after, thought was given to giving the customer more choices as to the types of coverage they can have and how much they would like to pay. So the TOEPP policy was then adopted 8 years later, as I said, in 2001. And in short, the TOEPP was created to provide the consumer with more choices as to policies, coverages, and price. Okay. Let's switch to the next slide. Okay, what is the TOEPP policy? We discussed that, but when can the TOEPP policy be issued? Well, the first requirement is it has to be improved property only. So let's say, for example, you have two tax lots, and one is improved and the other one is not. Can you issue the TOEPP? The answer is no. If either one of them is a vacant lot, the TOEPP policy cannot be issued. How about if you have two improved lots and one improved lot? Again, the answer is no. If you have any unimproved property, you cannot issue the TOEPP policy. But how about if the two lots are contiguous? The unimproved and the improved lots are contiguous. Does that change the answer? The answer is no. Contiguity does not make any difference. Again, if you have a vacant lot, you cannot insure or issue the TOEPP policy. Let's take again, so it has to be improved property only. The next requirement is 1 to 4 family residential property. That's the only thing it can be. So if you're asked to issue a TOEPP on commercial, you're going to have to deny that. You can't issue it on commercial. How about if your property has a small store in it, but primarily is used for residential purposes? So it's a mixed-use type property. Answer is still no, can't do it. It has to be 1 to 4 family residential property only. It cannot have any commercial use. If it does, the TOEPP cannot be issued. How about a residential condominium unit? Answer is yes. You can issue it on a residential condo unit, but you cannot issue it on a cooperative apartment. So you can only issue it for a condo unit, a 1 to 4 family residential property, but a co-op is out. You cannot issue the TOEPP on a co-op apartment. Next requirement, natural person. So the insured has to be a natural person. What does that mean? Obviously, a corporation can't be uninsured. A partnership or an LLC can also not be insured. They cannot be the grantees. If you want to issue the TOEPP policy, it has to be a natural person. However, can a trust be uninsured? The answer is maybe. If the trust is a living trust established by a natural person for estate planning purposes, you're okay. The TOEPP policy is possible. But so let's say, for example, I bought the property and I put the title in my brother's name as trustee for my living trust. The answer is it's okay. How about instead of my brother, I make a corporation of some sort as my trustee? The answer is it's still okay, as long as, again, the trust was created by a natural person for estate planning purposes. So again, the natural person is one of the requirements, and as well as a living trust. Okay, let me switch the slide. Okay, can an investor buy a TOEPP policy? The answer is yes. So for example, let's say I'm purchasing a summer home somewhere in Florida, 1 to 4 family, so it would qualify. Well, actually, it would be in New York, but some home in New York, which I will only visit during the winter. Is that okay? The answer is absolutely yes. How about if I buy a condo unit in Manhattan, which I have no intention of living? Instead, I intend to rent it out, basically an investment vehicle. The answer is yes. An investor can be the insured. There's no requirement that the owner reside at the property. As long as all the other requirements are met, which is improved property, 1 to 4 family residential, you are okay. How about continuation of coverage for a TOEPP? Well, the TOEPP, under paragraph 2 of the conditions section of the TOEPP, spells out certain scenarios where coverages continue. For example, someone who inherits your title because of your death, policy coverage continues. If your spouse receives title through a divorce, he or she will get benefits of continued coverage, as well as a trustee or successor trustee to whom you transfer title after the policy date, and to beneficiaries of your trust upon your death. So those 3 scenarios are clearly spelled out in paragraph 2 of the conditions section of the TOEPP. Section 32 of the TIRSA rate manual also applies, but I want to caution you that many of the options or variations that you'd see under Section 32 would not work. For example, let's say I transfer my title of the property to my LLC. I'm the only owner, and I'm the only member of the LLC, as my capital contribution to the LLC as allowed under 32(1)A of the rate manual. Can I do that? I can do that, but I cannot issue the TOEPP. And the TOEPP cannot continue in coverage because it violates the natural person requirement. So the Section 32 continuation of coverage provisions and options only work to the extent that they do not violate the other requirements. Okay. How is the TOEPP different than the ALTA policy? Well, first off, one of the key features of the TOEPP is that it increases 10% per year for the first 5 years. Pursuant to Section 10 of the conditions of the TOEPP policy, the policy amount will increase automatically by 10% per year. You do not need an endorsement to trigger that type of increase. It's an auto increase provision. So let's do a little quick example here. A TOEPP policy issued for $600,000 initially. A year later, it will now be, the liability coverage under that will be $660,000. On the second anniversary, it'll be $720,000, and it'll go on until after the 5th year, it'll reach a cap of $900,000. So your original policy, which was issued 5 years ago for $600,000, in year 5, at the end of year 5, will end up being $900,000, which is a 50% increase, 10% per year. Now, New York State, we should all know that New York State law requires that whenever we issue an owner's policy to a natural person covering 1 to 4 family owner occupied residence, we are required to offer the market value rider. The consumer can decline it, but we must offer it and get a waiver at closing. That's why in all your title reports you have that offer, and you have to have them sign off and say we decline to take it. That's because it's New York State law. Now, how does the TOEPP policy work with that New York law requirement, given the fact that it already increases by 10% per year as it auto increases? Well, the answer is there's a special TOEPP market value rider. And what that endorsement does is that basically if someone opts to take that, it basically removes the auto increase provisions that are contained within the policy, and therefore you then have an open-ended market value rider instead of the auto increases. Now, what may happen a lot is a purchaser at closing may turn to you and ask you, well, geez, which one should I go with? Should I go with the auto increase provision, or should I take the market value rider? And, well, first, as a title agent, you should not advise them. You should tell them to speak to their counsel, and their attorney should advise them. But you could point out that the auto provisions are capped at 50%, while the market value rider does not have a cap. It continues to increase as the property appreciates. Now, off to the side, if I was the purchaser, the way I would go about it is I would take a look at to see how long I intend to hold the property. If I intend to hold it for a few years, just a couple of years, quick turnaround, maybe a flip, I will, within the first 5 years, I think I would go with the auto increase provisions. If I intend to hold the property for a good 30 years, and I feel good about the fact that it will increase over the 50%, which it probably will over 30 years, then I will go with the open-ended market value rider instead. And I'll have a few more words on the market value rider a little later on when we talk about endorsements. Okay. Another difference in the TOEPP policy is that it provides certain zoning and building coverages, zoning and building issues. They are subject to deductibles, but it does provide coverage for loss resulting from the inability to use the property as a single-family dwelling as well. Another variation, and we'll discuss these in a little more detail when we go over each covered risk at 28. When we go over those, you'll see a little more detail how these work. Okay, now, the policy also, TOEPP policy also provides certain post-policy coverages, which are spelled out, as you can see, in covered risk 7, 8B, 21 through 24. And again, I will touch upon these in more detail when we get to those covered risks. All right, what's the format of the TOEPP? As I just said, there are 28 covered risks along with a statement of coverage. And just like the Alta 2006 policy, it has certain exclusions from coverage which are automatic. For example, it has a governmental police power exclusion. It has an exclusion for building and zoning. Okay, now you're wondering, well, what's wrong with Dennis? He just said that the policy gives zoning coverages and building coverages, but yet he's telling me it has an exclusion. Well, it does. But what that exclusion also has, it has language in it that basically carves out from the exclusion certain covered risks, thereby making those covered risks not subject to the exclusion. And those covered risks are 14, 15, 16, 17, and 23. They are considered the zoning and building covered risks. So basically, in a nutshell, the TOEPP policy does provide limited zoning coverages because of that carve-out language. Okay. It also contains an exclusion for post-policy events. Again, same thing. Dennis just said it provides post-policy events, coverage for post-policy events. And again, same thing, same setup. It basically has carve-out language which carves out certain covered risks from under the umbrella of the post-policy event exclusions. So covered risks, as I said before, 7, 8D, 21 through 24, the post-policy event exclusion will not apply to those covered risks. Therefore, you have post-policy coverage for those items. And the TOEPP policy also contains an exclusion for act of the insured, knowledge of the insured. Now, that's important. Keep that one in mind, especially when we talk about the post-policy coverages, because you will see that it'll play a significant role in limiting those post-policy coverages. And I think you can intuitively figure out that an underwriter is not going to protect an insured for his own acts that are post-policy. Okay, the TOEPP also contains a condition section, which contains a lot of miscellaneous things like definitions, continuation of coverage, how to make or submit a claim, what options the company has when processing the claim, the company's duty to defend, transfer of the insured's right to the company when we settle a claim. So it has some miscellaneous items very similar to what's under the 2006 policy, but it does have a condition section as well. The TOEPP policy also has a Schedule A, just like a 2006, but it has some variations. It has a policy number, title number, all the usual stuff, but it also has a couple of things that you do not find in the Schedule A of the TOEPP policy, of the 2006 policy, is it has the address of the property, as well as a schedule of deductibles and liability caps, which for certain covered risks, which is not something you would see in the 2006 policy. The TOEPP also has a Schedule B. Nothing really spectacular there. It includes exceptions just like an ALTA 2006 policy would, but keep in mind you would do the same type of searches as you would for the ALTA 2006, but there are other things you'll have to do in addition to those type of searches, a full search, full 40-year search, because of the enhanced coverages of the TOEPP. You'll have to do certain building reviews to cover zoning issues and post-policy events, and I'm going to get into that a little bit later, but just like make a little mental note that since the policy does provide additional coverages, you will have to do a few additional things. Okay. What are the limits of coverage under the TOEPP? Well, first off, and obviously, it's the policy amount, which I alluded to could be increasing by every year by 10%. So if you're looking at a face amount of $600,000, like I said before, depending on what year you are in the first 5 years, you're somewhere between $600,000 and $900,000. So that's one of the limits to the coverages. And as I mentioned quickly before as well, there are certain deductible amounts and maximum dollar liability amounts that also limit coverage for certain covered risks, 14, 15, 16, and 18. And just to go over some of those deductibles, for covered risk 14, the deductible is $2,000, and the maximum cap liability is $10,000. For covered risk 15 and 16, they both have a deductible of $4,000 and a cap of $25,000. And cover risk 18 has a deductible for $1,500 and a $5,000 cap. But we'll get into cover risk 18 as well a little bit later, because that only applies to a portion of cover risk 18. Okay, it also limits on coverages are exclusions, as you could expect. Just like under the 2006 policy, exclusions limit the coverages. I mentioned them already, the key ones. The exclusions do not vary. They are boilerplate. You'll find them in each policy. They do not change. And of course, exceptions also limit coverage. Those are exceptions on Schedule B. And unlike the exclusions, the Schedule B exceptions are specific to the property and vary for each parcel. And that's basically because, as we all know, each parcel has its own encumbrance story to tell. Okay. Oh, good, moved. All right, let's get into the nitty-gritty here. What are the 28 covered risks of the TOEPP policy? You're looking at the first 6. The covered risks 1 through 6 are the same as provided in the ALTA 2006 policy. Someone else owns an interest in your title. That's the first one. So, for example, someone comes forward, asserts that they are the rightful owner, it shows you a deed. Shows you a deed that was recorded before yours. It's from the same grantor. Well, that certainly is going to be a claim under the TOEPP policy, just like it would be under the 2006 policy. Okay, what happens if someone surfaces with a prior recorded lease, contract, or option that also trumps your deed? Well, that would also would trigger a claim under the TOEPP, just like it would under the ALTA 6, 2006. And that is cover risk number 2. If someone claims that a deed back in the chain was forged and as a result they are the rightful owners, it would also be a claim under the TOEPP, just like it would be under the 2006 policy. That's cover risk number 3. Number 4, someone's claiming or asserting an easement right. Again, that's a covered risk under the TOEPP policy as number 4, while, again, it's no different than what you'd find on the ALTA 2006 policy. Number 5 and number 6, basically same thing. I mean, if anybody asserts a right that predates your recording of your deed recorded, that somehow limits your use of the land or somehow makes your title defective, those are all covered under the TOEPP, just like they would be under the 2006. So far, there's no difference. But now, before we go to the now, here's your first program code. I'll give you a minute to write that down. It is enhanced, as an enhanced coverage. It's enhanced. I'll wait a few seconds here. Write that down and see it. Okay. Now, so as I said, so far nothing new under the covered risks. 1 through 6 were the same as we've seen all the time. So what's changed? Cover risk number 7 changes things. What it does is it provides post-policy coverage for those cover risks 1 through 6. So now, this is an extension. This is not something you see under ALTA 2006. So now, if someone comes with an interest under number 1, or a lease, contract, or option under number 2, or claims forgery or impersonation under number 3, or an easement number 4, or some kind of a restriction on your land or defect that's post-policy, your policy, the TOEPP policy, will cover it. So that is a departure, again, from the 2006 coverage, ALTA coverage. But I want to mention one thing to you. As we've said, we mentioned that there are exclusions to the policy. One of the exclusions is act of the insured. And these post-policy coverages are all limited by that exclusion. So if the insured played a role post-closing in creating that interest under covered risk 1, or somehow was involved in the lease, contract, or option under 2, or the easement in 4, or the restriction under 5, or the defect in 6, well, then it's not going to be covered. It's going to be excluded in the act of the insured. So if you put those two together, what you have basically is under through number 7, you have coverages that are really mostly, for the most part, duties to defend against what I would think would be claims that are going to be winnable. I wouldn't call them frivolous, but mostly frivolous claims, or claims that are asserted post-policy. We'll be able to deny it because we can say our deed trumps it. And if it's not, the insured would have to play a role in most cases, or almost all cases, for it to be an effective loss. So keep that in mind. The act of the insured defense plays a pretty big role in limiting coverages under the post policy for those 6 items. Okay. Covered risk number 8, this is not new coverage. This is also covered under the ALTA policy. For example, if the title company misses, this is routine for us, if the title company misses a judgment or mortgage that is docketed before the recording of the deed, it would be a claim under the TOEPP, just like it would be under the ALTA policy. But I want to point your attention out to 8D, because that one seems to, again, imply, or it does have certain post-policy coverages. And it basically refers to the lien occurring before or after the policy date for labor and materials, better known as mechanics liens to all of us. Now, I don't want to digress into a long discussion of mechanics liens and building loans, especially since in May, I believe, we have a CLE. Scott Spinner will be the speaker, which will focus on mechanics liens and building loans. But I do want to make a quick comment here, so it's a little bit helpful in relating to the TOEPP policy, is that remember that a mechanics lien can be filed by a worker or material lender for up to 8 months after work is completed. In the case of a single-family dwelling, they have 4 months. So it's entirely possible that the sale can occur within the time frame, within that gap. They could legitimately be filed after the policy date. So how do you protect against that? Well, the deed typically should have what's called a Section 13 trust fund provision. And that provision basically states that the grantor of that deed will hold the consideration of the transfer in a trust fund to basically apply it for the cost of any improvements before he uses it for any other purpose. So as long as the deed has that Section 13 trust fund provision in it, it'll be safe as to mechanics liens, or inchoate mechanics liens as we call them, that are filed during that time period after work has been completed, and that 4-month or 8-month window. So what you want to do is make sure that your deed contains a trust fund provision. And quite frankly, you should be looking for that trust fund provision in every transaction, not just a TOEPP policy, but an ALTA policy as well. Thankfully, almost all deeds have that as boilerplate, but you should still just make sure it's there. You should identify it and make note of it. So, in a nutshell, you do provide coverages against mechanics liens, but again, it's a duty to defend. We'll be able to point to the trust fund provision and say that our deed was recorded before the mechanics lien, and we'll be able to avoid a serious loss on that. And keep in mind that any mechanics lien that are past the inchoate period would have to require some kind of acquiescence, and the deed would have to require some kind of acquiescence by the insured. So if the insured somehow agrees to work to continue after he's become the owner, and that ends up having the mechanics lien being filed maybe a year after the deed, but it's a legitimate mechanics lien because the work was completed maybe 6 months after the owner took the title, it could be a claim. But again, we would deny that claim because that would be an act of the insured again. The insured agreed to the work and let the work continue. So again, there's after the insured defense again comes in to limit the post-policy coverage there. Okay, on to number 9 and 10. Nothing new to talk about here. These are not new coverages. It is already stuff that you'd see under the ALTA owner's policy. If someone comes forward and alleges, for example, that your grantor lacked competency or capacity or authority to convey, it would be a covered claim just like it would be under the 2006 policy. And neither of these two risks provide post-policy coverage. So there's really nothing new under covered risk 9 and number 10. Number 11, this is an extension of coverage from the ALTA policy because now access is extended to not just broad access, but it also includes vehicular access. So we must make sure that the property has vehicular access in addition to even pedestrian access. This is an extension of ALTA coverage. You must ascertain the vehicular access. If there isn't, you have to raise a specific exception that vehicular access is not insured. A good example of this would be possibly a property that, because of topography, you can't reach the parcel because only by car, but you can reach it on foot. So you have to raise it in that instance. Potential other problems would be a brownstone in New York City that might not have a garage in the structure or a curb cut in front of the building. In those cases, you should either not issue the TOEPP or raise a specific exception for lack of vehicular access. So whenever issuing the TOEPP, you have to make sure that the parcel has vehicular access. Okay. Cover risk 12 and 13 both relate to covenants and restrictions. Number 12, it basically ensures you if you are forced to correct or remove a violation existing at policy date because it violates CNR, and it's not enough if you accept out the CNR in Schedule B. You also have to accept out the violation of some sort to avoid a claim. So, for example, let's just say that you come across a restriction that on a parcel which says that you cannot erect a fence on the front portion of the parcel. You can only erect it up to the front face of the house, in other words, just the back of the house. You look at the survey, and you see on the survey that the entire lot, or the perimeter of the lot, is enclosed by the fence, so clearly that's a violation of the CNR. What you're going to have to do is not only accept out the CNR, but also accept out the fact that there's a violation because the fence goes beyond and into the front portion of the yard. And if this sounds familiar to you, it should, because this is the same type of procedure you would use if you're issuing the TIRSA 9 endorsement. You would not only raise the CNR, but you also have to raise the violation itself to avoid a claim. Side note on that, a condo unit, you're okay. A survey is not required for a condo unit. You can go with the standard condominium survey exception with affirmative language that you typically do. That's okay for the TOEPP. You can do that. Cover risk 13. Your title is, again, CNR. Your title is lost or taken because of a violation or any covenant restriction. And provided that such violation of covenant restriction is not accepted in Schedule B, again, you have the same type of mechanics as you would in a TIRSA 9 endorsement. So let's go for an example. Let's say that there's a restriction on the property which says that the property can only be used as a school. Otherwise, the grantor can re-enter and take back the property. So it's a re-enter provision. And you are now obviously being asked to insure it as a 1 to 4 family because otherwise the TOEPP is not available. So it's not enough to just raise the CNR. You have to raise the provision, which would be the re-enter provision, and the fact that it's been violated. And quite frankly, looking at this example, I mean, I don't think you should be really insuring it. But in any case, you would have to raise, if you are asked to insure it, you have to raise not just the CNR, the specific provision plus the violation itself. This is clearly an extension of coverage that is not available in the ALTA policy. Again, you have to raise not just the CNR, but the violation as well. And again, as you can see, the TOEPP policy incorporates into it the exception, cover risks 12 and 13. There's a strong TIRSA 9 endorsement flavor to it. And that's the last comment on those. Switch. Okay. Cover risk 14. This is where the zoning coverages begin. Cover risk 14 is the first one of the lot, and it basically covers the insured regarding certain zoning and building matters. In this case, it insures against loss by reason of a violation of a subdivision law or regulation. If there's a loss, the insured is liable for a deductible amount of $2,000, and the company's liability is capped at a maximum of $10,000. So, for example, you can't obtain a building permit, or you're forced to correct or remove a violation, or someone has a legal right to but refuses to act because of such a violation, then covered risk number 14 kicks in. One of the things we'd like to see regarding this covered risk is that the property to be insured must be all of a tax lot. If the tax lot has not been apportioned as a dated insurance, then the TOEPP cannot be issued. So again, you have to make sure that the property you're insuring is all of a tax lot. How about minor variations between the tax map and the record description? That's okay. If there's a minor variation between the tax map and the record description, that does not preclude you from issuing the TOEPP, as long as the exception for the variation between the record description and the tax map is noted and accepted in Schedule B. Minor variations are not a killer. Okay, covered risk 15 is the building permit covered risk, and that relates to the cost or forced removal of structures because they were built without a building permit, other than building boundary walls or fences. So walls and fences do not apply, they're carved out. So, for example, if the insured is forced to remove an addition to the house because there was no building permit obtained for it, the TOEPP policy would cover it up to $25,000. But again, the measure here is the measure of the cost of the measure of damages is the cost of removal of the offending structure. So keep that in mind. The deductible again is $4,000, just like it is. The deductible is $4,000, and the company liability is $25,000 for this item. And what you need to do here is you must, prior to closing, look at the building department municipal search and do your best to see that all structures and improvements were built with a building permit and that a C of O was issued. If you don't see a building permit, you can't issue the TOEPP, or you at the very least have to raise a specific exception for covered risk 15. And again, if we see any violations on the building department search, you really should not be issuing the TOEPP without speaking to company counsel, underwriting counsel. Chances are you probably will have to go to 2006 policy instead. Okay, covered risk 16. This is the zoning law violation. So if you are forced to remove a structure because it violates an existing zoning law or zoning regulation, again, other than a boundary wall offense, those again are excluded. At the date of the policy, you are going to be covered. And again, the deductible here is the same as it was under 15. It is $4,000 deductible and a $25,000 maximum cap liability. And again, this one relates to zoning laws. Number 17 is you cannot use the land because use as a single-family residence violates a zoning law or zoning regulation existing at policy date. Now keep in mind, 15, 16, 17, these do not cover post-policy. So there's no post-policy. It's just as existing at policy date. And again, just like 15, 16, 17, this is an extension of alter coverage. Here, in this particular covered risk, the threshold is much lower. If you merely cannot, if you cannot use the residence, I say much lower, but if you merely cannot use, it's not requiring you for a forced removal. It's if you cannot use the residence as a single-family home, the TOEPP will protect you. One other thing to take note with this particular covered risk, you'll notice that there is no deductible and there is no maximum cap on liability for this one. Okay, moving on to number 18. And before we go on to 18, 17 is the last of the zoning and building coverages. And 18 is where we start with the encroachment coverages. And number 18 is basically an encroachment that goes onto your neighbor's land. So you're encroaching onto your neighbor's land. Remember that. And again, if you're going to experience a loss that's because you're forced to remove your structure because it encroaches on your neighbor's land, covered risk 18 covers it. And this is really nothing that new from Alta 2006, because if you read in a survey and fail to identify the encroachment onto the adjoining land, there is liability under 2006 as well. The exception requires a survey to be read into the policy. And again, the loss is triggered by the forced removal of the structure. However, let's say, for example, it's a structure is a wall or a fence. Note that this exception does not have an exclusion or carve-out for boundary walls and fences, but it does have a deductible and a $5,000 maximum cap. So it will apply, cover risk 18 does apply to walls and fences that encroach, but those are subject to deductibles of $1,500 and a $5,000 cap. But let's say under 18 you are forced to remove something other than a wall or a fence. For example, you're forced to remove a pool or a deck that encroaches onto the neighbor's land. The TOEPP will cover it, but no deductible applies. The deductible only applies to a boundary wall or fence. And just a little note, covered risk 18 is the last covered risks that contain a deductible and a maximum cap. Okay. Marching along. Okay, number 19. This is the reverse. This is the reverse of cover risk 18. This is where the neighbor encroaches onto your land. And just basically the same stuff. but again, it's the reverse. The neighbor is encroaching onto your land. Cover risk 20, you are forced to remove your existing structure because you encroach onto an easement or building setback line. And again, here, you'll note that even if you accept out the easement or building setback line in B, it's not enough. You have to also raise the actual encroachment for there not to be a claim. So again, cover risk 20 also has that TIRSA 9 endorsement flavor to it, where it's not enough just to raise the easement or the setback line in this case, but you also have to raise the actual encroachment. And once again, the loss is triggered not by the mere fact of the encroachment, but by the forced removal of that structure. But just my opinion in general, general opinion as to regarding number 18, 19, and 20, those covered risks. These covered risks really have used really specific language. So in my opinion, I do not think that a general subject to any state of facts exception for a survey exception is worth it or works. I think a more detailed survey exception at the very least is needed, but I'll touch upon the survey issue a little bit later. That's a big question when it comes to TOEPP. So we'll get to that in a minute. I just wanted to point out that the language in these covered risks is pretty specific. It's hard for me to imagine that a general exception for survey any state of facts is really enough to insulate us from a claim. Okay, let's go on to number 21. 21, this is where post-policy coverages continue. And I'm going to have to speed up here a little bit because I'm a little behind. Here, this regards mineral rights. It is an extension of ALTA coverages. The cover risk provides post-policy coverage that is not limited by an exception in Schedule B. So if a third party has the right to extract minerals from your land, does so, and in the process damages your existing structures, there will be a claim under the TOEPP. That would not be the case under the ALTA 2006 if those rights were accepted in Schedule B, unless, of course, in the 2006 you've also provided affirmative language, then you may have a claim. But absent any affirmative language, 2006 would not cover it as long as it's accepted in Schedule B. Under the TOEPP, even if you accept it in Schedule B, there is coverage. Okay. Cover risk 22, I'm not really impressed with it. I think it's a throw-in. Most of us know that restrictions that are of these type are not enforceable, and in many cases really should not even be raised. But I guess at most, if a third party went so far as to bring an action trying to force one of these covenants, we would have a nuisance defense obligation. 23 is a supplemental real estate tax. Relates to supplemental real estate taxes. This is already provided under the ALTA owner's policy. If the tax search shows that the property is benefited by tax exemption, an exception must be taken for the restored taxes that may be levied upon the policy between the date of the exemption and the date of closing, if such an gap exists. Number 24 is an extension of ALTA coverage. It's the last covered risk that contains post-policy protections. Here, let's say the builder begins to build something on your land after post-policy, after the closing, and he's building a structure that encroaches onto your land. We will go in and basically make him stop. We have the duty to defend and have him stop and or remove what he's doing. But I want to caution that an insured who for some reason decides to take his time to let us know. Let's say he watches a neighbor build that structure, and then lets it sit there for 10 years. Well, guess what? That structure now may not be able to be removed because of possible accrued rights as a prescriptive easement or adverse possession. And under those circumstances, the act of the insured exclusion would come in. We've been prejudiced because no longer can it be removed. And so even that post-policy coverage also has certain limitations in it. We cannot be prejudiced by the insured's acts or lack of action there. Okay. Now I have to switch to next channel. Okay, we go. Switch over. Cover risk 25 and 26. Nothing new here. These are covered under the ALTA policy, and I'm not going to spend any time on them. Number 25 is basic marketability insurance. Number 27, I can't tell you how many times, just a quick comment, how many times when I look at highlights, submissions, and I look at the title report and I see in Schedule A a reference to the address of the property. So each time I have to say, listen, you have to either take it out completely, take out the address of Schedule A, or at the very least, clearly mark it as for information only when you're doing when you're issuing the 2006 policy. Well, here I'll be doing the exact opposite. This is an extension of ALTA coverage, and here you must ascertain the address of the property and insert it in Schedule A. And if there are multiple addresses, you have to list them all. So it's the reverse. Cover risk 28. That's basically land same as survey coverage, land same as survey endorsement coverage. That's all that is. I'm not going to spend much time on that either, especially since I'm running out of it. And there's still a lot to cover. Okay, premium, 120% of the owner's rate. It's a one-time recurring premium, and you get the coverages as you see below: standard ALTA coverage, automatic increase for the first 5 years if you don't opt for the market value rider. It provides certain limited zoning coverage we discussed, post-policy coverages and use as well. Okay. Endorsements, next slide. What endorsements are available? I already mentioned that the market value rider, there's a unique market value rider for the TOEPP policy. The premium for that one is 5% instead of the 10% which you get under the original, under the typical market value rider. And again, what that basically does, I mentioned it before, it basically deletes the auto increase provisions of the TOEPP policy. Instead, you end up with a open-ended, non-capped TOEPP market value rider. New York endorsement is not available because it's really not compatible. Most of the coverages in New York endorsement are already within the TOEPP policy. Waiver arbitration is available for the TOEPP policy. Okay. Oh, we've reached your second program code. Second program code is post-policy. Post-policy. I will leave this up for a few minutes so you guys can write it down. Don't miss it. Okay, again, the program code number 2 is post-policy. And I'm going to switch the slide in 3 seconds. 2 seconds, 1 second, time's up. Okay. What are the exceptions or exclusions from coverage? Again, I've gone through these, which is good because I'm running out of time. One of the most important exclusions is, of course, the accurately insured. I mentioned it throughout how it does limit certain post-policy coverages. Makes sense. Why would an underwriter insure the insured from his own acts if the insured acted in some way to make the problem worse or create the problem? We're not going to cover it. We're not going to bail them out. Okay, $1 million question is how about surveys? In order to obtain the full benefit of the policy, a survey is recommended. If not, a survey exception, a more significant one, as you see on the right side of this slide, should be added. My position, though, is although it says survey is recommended, mostly because this is not really a requirement under the TIRSA rate manual. There's nothing that requires you to use a survey. My position is a TOEPP should not be issued unless you have a survey, and the reason basically is that the TOEPP is intentionally an enhanced product for which the insured is paying additional premium. He's paying 20% more. A broad sweeping survey exception really neutralizes many of the benefits of this policy to the point that you're almost just as well issuing the 2006 ALTA policy, but yet you're collecting 20% more premium. I think it's kind of a disservice to the insured. I think you really need to issue the TOEPP policy when you have a survey. Okay. Zoning coverages. We went through this, but just to mention again, the zoning or the policy does contain a zoning exclusion. But don't be confused. It still provides zoning coverages because the language of the exclusion has a carve-out for certain exceptions. Okay, we've already gone through that. It also provides certain comments regarding the zoning coverages, coverages for conditions existing at the policy date. So zoning coverages are not mixed with post-policy coverages. Just keep that in mind. And the coverages for forced removal of the structure or the inability to obtain a building permit. As with the ALTA policy, the exclusion does not apply to matters that are appearing on public record. So if it's of record, it's covered. Cover risk 15 and 16 do not cover boundary walls or fences, and cover risks 14, 15, and 16 are all subject to deductibles. They are listed in the policy in Schedule A. Okay. Moving along, post-policy coverage, the same thing. There is a post-policy exclusion, but again, it has carve-out language in it that removes certain covered risks, which we went through from its umbrella. Those are any covered risks 1 through 6, mechanics lien coverage after the policy date, supplemental real estate taxes not previously assessed or covered, or your neighbor starts building something on your property after the policy date. We'll go in and make them stop. Okay. Claims. Nothing really new here. You have to submit the claim promptly. Once you become aware of a claim, you need to submit it timely. Description of the claim is needed, a copy of your policy, and any other supporting documentation. That's standard procedure, nothing new. Again, keep in mind that the title company has a reasonable time to investigate and, if necessary, litigate the claim. Okay, let's get to number 22nd slide. This is important, but nothing new. We've gone through this, but this is a recap. What you need to do, in addition to the typical stuff you do, searches and stuff like that you do for the ALTA 2006, these are additional things you have to keep in mind when you're issuing the TOEPP. 1 to 4 family, unimproved land, natural persons, corporations, partnerships, LLCs are no. Vehicular access must be verified. TOEPP policy should not be issued unless a survey acceptable to the company is provided and read into the policy. If there's a violation of any CNR, both the CNR and the violation must be accepted in the title certificate. Okay. Number 7, the property to be insured must be all of a tax lot. Minor variations are okay. A building department search should be performed to determine that all structures and improvements were built with a building permit. You also have to see if there's a corresponding C of O for each building permit. If not, you have a problem, and you have to take a specific exception for covered risk 15 due to the lack of a permit or for a particular improvement. A building permit and certificate of occupancy search should be performed in connection with every request for a TOEPP. There should be no pending or current construction affecting the premises in question. If your building department search reveals a violation, do not issue the TOEPP without at least speaking to underwriting counsel. We'll assess the situation. We probably will suggest that you issue the ALTA 2006, but nevertheless, speak to us before you do anything regarding a TOEPP. A survey being read into the title policy should be compared against the C of O search to determine whether any of the improvements have been added without a C of O. This is the date of the survey. And again, number 11, as previously stated, a survey acceptable to the company must be read at the title. It has to show all encroachments, buildings, walls, and fences, nothing that we would normally do. If there are any encroachments or onto easements or setbacks, both the easement setback area and the encroachment must be set up in Schedule B. Number 12, the address has to be listed in Schedule A. The seller should execute a TOEPP seller's affidavit, which is in your materials, starting on page 26 and 27. It's towards the back. I believe it's the second and third pages from the back of your materials. The TOEPP market value rider should be offered just like the market value rider will be offered in every transaction. And again, just overriding thing you have to remember, if for some reason you can't issue the TOEPP, that does not mean you can't insure the title. You can just go back and insure with the Alta 2006. Or, for example, there's a zoning issue. You can't issue the TOEPP. You can still issue the Alta 2006, possibly if there are no other issues that preclude you from doing so. Okay. This recap list that I've just gone through rather quickly, you can find that in your materials. So you have a copy of it. It's beginning on page 11 of your materials. Please make sure to study it whenever you're going to be issuing a TOEPP. And just going over the materials very quickly here, pages 1 through 9 of the materials is basically the presentation I just went through. It just doesn't have all the wonderful pictures. And next. Flip. Okay. What you're looking at now, the slide, this one, and the next few slides comes from a marketing handout that we at FNTG prepared, that the FNTG agency prepared. You can find that handout, a copy of what it looks like, on pages 9 and 10 of your material. It's a nice little thing. It basically summarizes all the wonderful coverages. It puts them in nice, clean order for you. This is the first page. Second page shows you the post-policy coverages. And then you have zoning and building coverages all summarized. And again, you have that. It's in your materials on pages 9 and 10. And let's see what we have here. And the last few pages of your material, beginning on page 13, is a copy of a TOEPP policy. And as I said, I think the last few pages, you'll find a TOEPP policy affidavit. So again, summary handout is on page 9. Recap, which is very important, is on page 11. And the TOEPP policy copy of it is on page 13, and the affidavit on 26, 27. And finally, your last program code, zoning. Program code number 3, zoning. I'll leave that up. Make a countdown to 10, I guess. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. I am done. And you have all 3 program codes. And Dana, I'll hand it over to you.
Dennis, thank you so much. That's our program for this morning. Just a reminder for everyone to please return your attendance verification forms and evaluation forms to me. We thank everyone for joining us this morning, and we hope you have a great day. If anybody has any questions about the program, feel free to email Dennis or I. Thanks very much. Bye.